Hey everybody, this is Joe Rodriguez. Here is the truth that most anesthesia providers don't know about being sued. Getting sued for malpractice doesn't mean that you're going to lose or that you did anything wrong. But the way you handle it and what happens after you're caught in litigation or you get served or you get sued, that's what can really make or break the outcome depending on who you're working with. So welcome back to Anesthesia Deconstructed. Today, we are talking about what really happens when a CRNA or an anesthesiologist is named in a lawsuit. From the first phone call to the depositions to what separates defensible cases from potentially career-ending mistakes. Guests for today are Paul Lefebvre. If I'm saying that correctly, he's an attorney. He's the lead claims professional and risk advisor, as well as Andrew Clark, the head of business development at Physicians Preferred Medical, a anesthesia-specific malpractice carrier that's been in the trenches with providers for a long time. Just a disclaimer, this is not an advertisement for them, but the group I'm part of does work with them directly, so we do have a relationship outside this podcast. We cover some of the most common mistakes that providers can make, why most, not all, but most anesthesia lawsuits are defensible, how to immediately lower your risk, right? And how your choice of carrier makes a bigger difference than you think. So if you're a CRNA or an MD or you're a group leader, this is one you should enjoy. Let's get into it. Hey everyone, real quick, if you're listening to this, you're probably the kind of anesthesia provider who wants to understand more than just how to push drugs. This podcast is about understanding what's really going on, whether it's legally, clinically, or financially, and the often small but powerful ways you can protect and advance your career outside of the OR. Anesthesia Deconstructed is already one of the top podcasts, at least in anesthesia, out there. We get a few thousand listens per episode, but subscribing helps us keep that momentum. And it helps us bring on more compelling guests, better commentary, and the kind of insight that actually moves our careers forward. Subscribing is free. It helps us keep doing what we're trying to do, and it means you'll stay sharp, connected, and stay a step ahead. So please hit the subscribe button and enjoy the show. Today we have Paul Lefebvre, who is let's see if I can get this right, the lead claims professional risk adjuster. Did I get it right, Paul?
Close. Lead claims professional and risk advisor for...
Advisor.
That's it. You got it.
For PP&M, Physicians Preferred Medical. You manage the moderate and high severity claim and litigation files for anesthesiologists, CRNAs, CAAs, and anesthesia practices. And also complementing him is Andrew Clark, and you handle business development for PPM. Guys, thank you so much for being on Anesthesia Deconstructed.
Thank you for having us.
Of course. All right, so let's jump right in. The one thing, so you guys are obviously subject matter experts. Okay. What is the one thing that CRNAs and anesthesiologists don't know, but should know when they're being sued for malpractice? Let's start there, and then we'll just operate organically after that.
Sure. Well, each case is a little unique, but I do think that something that I think the community, anesthesia community, will serve to know is that the vast majority of the cases, the claims, lawsuits that we defend are defensible on the medicine. So when a new claim or lawsuit comes in, obviously it's a scary time in a person's life. And I think that just based on 37 years of handling nothing but anesthesia-specific claims and lawsuits, our track record and our loss experience would suggest that most of these cases, save for a few areas that we can talk about a little bit later on, areas of exposure potentially, but the vast majority of cases are defensible on the medicine, and we're going to get you through it to the other side.
So it sounds like I've been told and read that something around 90% of malpractice cases are dismissed or settled with minimal impact to the provider. Paul, would you say that's a fair characterization?
Yeah, that's fair. I'd say for us, the settlements would usually between 10 and 20% of the lawsuits that are filed result in indemnity payment, claims and lawsuits, and vast majority are dismissed. And the ones that proceed to trial, vast majority are defensible on the medicine, and about 92% in recent years. Time when we go to trial, result in a defense verdict.
Okay, fair enough. And what about you, Andrew, from the effectively the sales or the business development side? Something that CRNAs and anesthesiologists usually don't know, but they should know when they're dealing with malpractice issues or when they're sued.
Yeah, I would say asking your current carrier whether or not they insure other parties that were in the OR at the time. So, something that's pretty common that we hear when we're discussing whether or not a prospect should join PPM is the shifting of liability. So if you are the anesthesia provider, let's say the surgeon's in the room, maybe there's another anesthesiologist who comes in, everyone has $1 million on the table. If you're all insured with the same carrier, it doesn't really make sense from a financial perspective for that carrier to spend $400,000 in attorney fees to get you specifically out of the case just to shift the liability onto someone else who's in the OR at the time. Ultimately knowing that they could end up spending $400,000 on that person as well, or paying out the policy limits.
So
go ahead.
Yeah, go ahead. Go ahead.
Yeah. It's just important to know who, when you're in the OR, which carrier they're with. Make sure that everyone has the same limits, and parity of limits is something that we talk about a lot too, and I can elaborate on that a little bit later.
Okay, yeah, fair enough. And maybe that's a good segue, because I know I want to make sure to get the history of PPM on record, so to speak. PPM is anesthesia-specific. You just mentioned about knowing effectively who is protecting whose interests are aligned and maybe only partially aligned. But could you speak to a little bit about the background of PPM, because I know it's anesthesia-specific?
Sure. Yeah, so our company was founded by an anesthesiologist back in the late 80s, kind of under the premise that at the time, and this is still true to some extent to this day, there was quite a bit of subsidization occurring between specialties. So there was an incongruency in the risk to premium ratios when you're looking at anesthesia versus OB, neuro, some of the higher risk specialties. And so the losses that weren't occurring for anesthesia, the premiums from those policyholders were being used to subsidize the loss experience of some of the other specialties. And so there are really kind of three basic pillars on which the company was founded. There's the anesthesia specificity piece, primarily kind of grounded in that subsidization that I'm talking about. We really focus on proactive anesthesia-specific risk management. And so 100% of Paul and his team's time is spent on anesthesia claims, anesthesia risk management, focusing on your specialty and in helping you to improve patient safety and avoid adverse events.
Of course.
And then the third pillar is aggressive defense. And so Paul kind of talked about that. A lot of the times these claims are defensible. And we believe that, you need the opportunity to stand behind your good care and to defend yourself as an anesthesia provider.
Yeah, that makes a lot of sense. And because you mentioned being subsidized a number of times, so just to kind of zoom out on the economics of it. So effectively what you're saying, for those who are not familiar, anyone who's running an anesthesia practice, by the way, is very familiar with subsidies right now. And I'm talking to my counselor about this regularly, and my therapist says I can talk about it in public now because it's very painful. But I digress. That's an issue for another episode. But as far as anesthesia subsidies, effectively what you are saying is the premium dollars, the dollars coming out of the pockets of anesthesiologists, of CRNAs, is going from their pool of risk that's meant to defend them, right? And they're taking, because that pool of dollars is getting sufficiently large because of the low claims and low payouts, companies would take that money and put it into other specialties and use it to defend them. Is that a kind of a layman's understanding of it?
Yeah, I think that's a good explanation. And a good analogy would be the LA fires that happened relatively recently. So,
okay.
Lots of big $1 million homes, expensive cars that were torched in the flames. And, the premiums from some of the other communities surrounding and nationwide, if you're looking at, the all states of the world,
yes,
are used to subsidize those losses.
Yes. Does and this is for the insurance nerds who are listening. Does PP&M have their own actuaries who are are effectively math professionals who are calculating the risk of anesthesia-specific claims?
Yeah, we have an actuary in-house who does exactly that. He puts together some of our special programs, like risk-sharing programs for some of the bigger groups. And then also, one of the things that he does that kind of sets us apart, he keeps his thumb to the pulse really, really well of filings. So anytime rate changes are filed nationwide, he puts them on a spreadsheet, presents them to the rest of the company, gets that information in our hands so that we know exactly what's going on in the marketplace.
And when you say on the filings, you're talking about, because this is really interesting diving into the business end of it. I didn't anticipate it. But you're effectively saying your actuary is watching what people are paying for premiums or who's getting sued and settling. Those are two different buckets.
Yeah, we're talking about premiums. So
okay.
Insurance is a regulated industry. When you make changes to your filed rates that are above usually 5%, but it does vary based on the state, then you have to publicly file them, provide an actuarial explanation of why you think they're justified. And so we have access to those, and we use them in our decision making as well.
Okay. All right. That makes sense. And you said PP&M started by an anesthesiologist. Great. In your part of the world, out in the center of the country. Now you guys are insuring people nationwide, correct? You're insuring, as we mentioned at the top of the introduction, all sorts of anesthesia professionals now. How long have you been insuring CRNAs? And, just out of curiosity, what was the driver behind that? Besides expanding the market, right? I imagine there was some risk evaluation that went on there, right?
Yeah, we've been insuring CRNAs as part of the care team model for basically our entire company's history.
Okay.
Now, we've really, within probably the last 5 to 6 years, deep dived into 1099 style CRNAs, putting together risk management programs that really focus on what they have going on, a lot of endoscopy and ASCs and that sort of thing. But, as the market expands and the advanced practitioners continue to expand their scope of practice, it just makes sense from a business perspective for us to focus on them as well.
Okay. Yeah, that makes sense. I want to kind of flip over to the clinical side a little bit. So, Paul, in your role, I imagine, how long have you been at PP&M now, Paul? 2018?
I joined PPM in 2018. Yep. So
okay, got it.
7 years here pretty soon.
Okay. And just for context, were you in the anesthesia malpractice business before or industry before that? Or is this your first foray into anesthesia world?
It was the first foray into anesthesia world, as well as insurance side. So before I joined PPM, I was with the Missouri Board of Registration for the Healing Arts. I was general counsel for the Medical Board of Missouri.
Okay, duly noted. All right, that makes sense. So you've probably seen both at the medical board and certainly in your role now, I imagine you're overseeing hundreds of claims, a lot. I don't know how to quantify it, actually. But is that a fair assumption? A lot of lawsuits that you've overseen or reviewed or been part of? Sure.
So we're actively defending several hundred claims and lawsuits at any given time. We have about 500 adverse events reported to us, between 350 and 500 on a given year. Obviously not all of those result in a claim or a lawsuit. I think Andrew will talk about it a little later. We can visit about, some of the misconceptions about reporting incidents and things like that. So we've got 5 in-house attorneys that are in our claims department. So we're all able to offer guidance to our insureds when they call in, and the vast majority of those, what we'd call an intake, come in through the phone. So just policyholder or insured picking up the phone, giving us a call after an adverse event or just looking for some guidance.
Yeah. What is, in your view, Paul, what is the biggest mistake that CRNAs, anesthesiologists make during the lawsuit process, right? And I realize there's many stages of a lawsuit, but generally speaking, perhaps early on, what's the big thing that people do that they shouldn't do?
Sure. I think that, right out of the gate, we try to, again, some of the things we touched upon earlier about the defensibility of the cases. And it's easy for me to say on the phone. I appreciate that. It's really hard on our our insureds when there's a sentinel event or a significant complication that a patient experiences. Lots of times they don't anticipate that resulting in a lawsuit. Sometimes they might. But I would say along the lines of the bigger mistakes that we see is we work with, we're single specialty, and we work with, a handful of attorneys in each given state. So they've got lots of experience defending anesthesia professionals as well. And probably some of the pitfalls or rakes that we want to avoid stepping on are maybe not following the guidance of counsel, when they're about, conversations or just, in preparation for depositions, things like that. I think we've had a handful of defensible cases that can be complicated by a poor deposition, maybe because they didn't listen to defense counsel.
Yeah, I imagine when people don't listen to their defense counsel, either from PP&M or the barred individual in that state who's actually quote representing, if I'm
that's right
characterize it.
We're not representing the individual policyholders. We're
right.
overseeing the claim file. Yeah.
Right. When people do that, why do you think? What's a generalization that I suppose people can learn from? Why do you think people don't listen to their defense counsel? Is it because they feel they can figure it out on their own? Right. These are highly educated people that you're insuring. Yep.
I think that's probably the biggest factor sometimes. But the specialty that we insure, we don't necessarily always have the huge personalities in the room. Maybe these are few and far between. Maybe some other specialties experience that issue a little bit more often. But
are you saying that's why I don't fit in, Paul? Are you saying
no, that was a shot at the surgeons.
Yeah. Oh, okay, I got it. Oh, all good. Good. I understand.
No, they're good. So it's times where I've been in an operating room twice in my life for both my kids.
Okay.
Both my kids were sections, and that was my experience. So the first one was pre-PPM. The second one was post-joining PPM. So it's very different observations. I was watching what the CRNA who was handling the anesthesia services for my wife was doing more on the second one, just to see, evaluating the informed consent process and all that kind of stuff.
Yes. Hopefully they did.
Basis.
Hopefully they did well, and shared all the relevant risks.
But it's an uncomfortable place to be. I'm outside my element. They hand you your kid and there's 19 wires to trip over and got to go through 3 things. And, it's, imagine it's similar for, doctors and advanced practice clinicians who have never been in a courtroom before or never had their deposition taken. So I think these are all experiences that we don't anticipate, that we don't, it's not front of mind. We're not thinking about how we can be a good witness during a deposition before a lawsuit's filed. And I think that sometimes there's some preconceived notions about the medical legal system in general, and kind of outcomes are preordained, and this is all just a formality, which really isn't the case at all. Every case is unique. Every defendant in a case is unique. Every situation is unique.
Yeah, I think for 2 observations there, or 1 observation and a question rather. I think to outside watchers, when you don't know about a high knowledge subject matter, everything looks somewhat similar, right? People look at anesthesia and they think white stuff, yellow stuff, right? You're pushing propofol, you're spinning sevoflurane, you're putting a tube, and it's like there's so many areas where you can screw that up. And I imagine it's similar with legal proceedings. Do you think that's fair, Paul?
I do. I think that, and part of the guidance that at our local counsel that we insure to represent the individual insureds, they'll often tell them, if you don't remember something, that's okay. You can rely on your medical record. You can rely on your custom and practice. Oftentimes the doctor or CRNA will give us a call and let me know they were served with a lawsuit. And one of the first questions I'll ask is, do you remember this patient encounter? It was maybe 2 or 3 years ago. And more frequently than not, they'll say, I don't have any recollection of this case. It was just, didn't know that there was this complication, did not anticipate this, don't have any recollection of this particular patient encounter. And that's usually a pretty good indication for me that this is the type of case that we can routinely defend. Again, they can, plaintiff's attorney may identify something in a medical record, or it might just be based on damages, or an inexperienced plaintiff's attorney that thinks that every case, if there's a complication or an adverse event, that somebody's paying on the other end. And so that's types of things that we'll navigate.
Okay. Yeah, that makes sense. You mentioned plaintiff attorneys, and from your point of view, Paul, knowing, and feel free either of you to answer this if either of you want to weigh in, are plaintiffs' attorneys financially motivated to file claims, which in a way that could cloud their judgment on what's legitimate and not legitimate?
Well, I don't want to make a overgeneralization, but I think that they're oftentimes focused on the damages side of the case. They don't, whether there was a departure from the standard of care, even a link on the causation element of a case is kind of secondary. We look at a case and I start there. Was there a departure from the standard of care? There's not. Don't move on to the next step. This is a case that can be defended on the medicine. Let's do it. Sometimes, there's causation issue where we can defend it as well. And if we get to those points where we've got concern, our experts that we retain to work with us on the cases identify some areas of potential exposures with regard to a departure from the standard of care and it resulted in the patient injury, then we'll get into damages and we'll take a look at it. I think lots of times when plaintiff attorneys take these cases, they look at the damages first and foremost. The medicine is secondary, and that's.
Are they? And this is just me being curious about the industry itself. Are plaintiffs' attorneys typically paid in terms of a percentage of damages?
Exactly. Yeah. So it's almost exclusively contingency fees across the board. So they get a percentage.
Right.
Yeah.
Right. And so for those who don't know, right, effectively, it's funny because for most anesthesia professionals, they are paid upfront, right? We get reimbursed, many months later, and most of us don't have that understanding of the rest of the industry, so to speak. But that effectively means plaintiffs' attorneys won't take anything upfront. They'll get paid only if they win, and then they'll get paid a percentage. Does that sound right?
That's right. And they're also investing a significant amount of money into legal expenses throughout the course of that lawsuit as well. So which comes out of any award, if there is one at the end, or settlement, that'll come off first. So they've could be tens or $100,000 in experts and deposition transcripts and all the other costs and fees that go into bringing a medical malpractice lawsuit.
Okay. Yeah. And that's, again, just for clarity for the audience, this is not meant to, and my question is not meant to criticize plaintiffs' attorneys. So certainly there's the system needs plaintiffs' attorneys at times, but it is more to identify the general, how the industry actually works. Right. Yeah. So,
and it's good for listeners to know that too, that just because they're named in a suit, it doesn't mean that they did something wrong. That's what we're here for, is to, it's oftentimes not the pursuit of the truth. Plaintiffs' attorneys may want to frame it that way, but it'd be pursuit of recovery of damages. But if we have expert support in these cases, and sometimes some of the cases that we'll get drug into, it's clear we're only there because we're another insurance policy. This is not an anesthesia-related complication. This is clearly a surgical complication. And frankly, oftentimes the surgeon can defend those cases on the medicine without us as well. Some sophisticated plaintiffs' attorneys might try to pull in a few different parties to see if they can induce some finger pointing. Again, that goes back to the lack of maybe preparation or direction from counsel during the course of litigation, where those are really some of the bigger things that we want to avoid, because it's not like everybody adheres to the standard of care on the road. Short of a deer running out in the fog in the middle of the night, there'd be no accidents if we didn't. Usually, if there's an accident, somebody departed from the standard of care of operating a motor vehicle on the road. But we're not immortal. There's complications, and sometimes it's a choose your own adventure. We've got three choices. We're going to have a robust informed consent discussion with the patient and patient autonomy, and they make a decision that the risks the benefits outweigh the risks of the procedure, and the patient decides to undergo a procedure and they experience one of those complications. We don't know what would have happened had they chose something different, and hindsight's always 20/20, but the critiquing of the anesthesia plan and things like that, Monday morning quarterbacking, those are the types of issues we got to navigate.
I always tell people, you give me 30 minutes with your chart and a good lawyer, and I will find something you did wrong, right? Like anyone can go back, and Monday morning quarterback those issues. you talked about, there's actually two parts there. So you mentioned deposition, right? This is a key part. It is part of the legal proceeding, right? It's not a warm-up. It's an actual legal proceeding. I want you to critique the advice that I have given to other people through my experience. And for context, I've been involved in a few different, as an expert witness, the case I was involved in personally, I got dismissed very early in the process. But effectively, when that occurs, the first thing I do is tell them to call whoever their malpractice carrier is, right? And as a disclaimer, obviously, we insure with you guys, and we think you guys do a great job. So in my specific case, I'd be referring them to you, Paul. But usually we have a conversation first. And when these things come up, I usually advise, like a one-on-one, just a colleague-to-colleague conversation. I usually advise the following. And the first is, it's really three things. The first is I tell them to tell the truth, right? This seems obvious, but I think for people who are at what they perceive to be a deleveraged position, they feel like they're extremely at risk. They're being scrutinized. So they become really worried about how they answer and how it can be misperceived and misconstrued and all that sort of thing, which leads to the second 2 points. And this is what I'm curious on your input on. I try to tell them to say, hey, you need to look at the context of the question. As in, if someone asks you something like, wouldn't you say it was reasonable that this would have had a different outcome if you hadn't done X, Y, and Z, right? And it's obviously this is the context of that it's a very leading question. And then I will tell them to answer only what they truly know, as in, I have no idea what the outcome would have been if those other things had occurred. What I can tell you is that, right, the standard of care was met. Here's why it was met. And effectively to stick to that main message, answering the specific question, but also keeping in mind the broader context, which I find is very difficult for people to do, especially, as you said, in this specialty, a lot of type A people, a lot of hyper detailed people, a lot of people where they really are driving down on very specific details, and they can be very hard on themselves. So, but I try to get them to see the broader picture as well. So tell the truth, know the context, and only answer what you know. Otherwise, say, I don't know.
Yep.
Right?
And listen to the question.
About that?
Answer the question that's asked as well. I think that's a frequent pitfall sometimes we'll see during depositions, is that you want to defend your case on question number 2. And your attorney is going to have an opportunity to ask you some questions as well. This is something that we encounter, particularly at trial, where plaintiff's attorney is on cross and able to ask leading questions that require yes or no answers. And sometimes you may not want to give a yes or no answer because you know what he's doing, but have faith in your defense attorney is going to be able to come through and help clean up some of those responses or questions, or whatever the other side's trying to imply. And frankly, lots of times those strategies backfire because the jury, is watching those things. And if they feel like one party's trying to trick the other one, you ask the same question 4 times and you don't get it. And then you get it on the 5th time where they elicit the response that they wanted. And, then that's all part of their closing argument. Of course, the jury sat there and listened to, the defendant answer the question honestly 4 times in a row, and you kept coming back to the well. So, listen to the question carefully, following the guidance of defense counsel during that deposition prep. And again, like we said, it's always okay if the answer is, I don't recall, or I need to look at my record to refresh my recollection of that. And that's easier for the specific clinical questions. It becomes a little bit more challenging when you present those types of hypotheticals that you were suggesting about the patient's outcome and things like that as well. But they'll be prepared. Indeed.
Makes sense. All right. So Andrew, obviously what Paul is sharing, I think, is part of the value proposition for PP&M specifically, right? Because I want to answer 2 questions here. First of all, this type of advice from your standard malpractice brokerage, right? Is that available? To what degree? And then more broadly speaking, with PP&M, what's different about PPM than those other options, right? Than the Baxters or whatever else is out there?
Yeah, so I think when you think about anesthesia or anesthesia providers as a percentage of the overall pool of medical providers in the U.S., it represents about 6%. And so if you think about a big multi-specialty carrier out there with only 6% of their book of business being anesthesia, I mean, it really makes sense that they wouldn't be able to devote the time and resources, have the Pauls of the world out there answering these very specific questions, because it's just financially imprudent to spend that amount of resources on 6% of your book. Another kind of piece of the puzzle that sets us apart, that allows for this type of communication to occur, that Paul's talking about with the managing the claims and managing the local defense counsel. We're a direct writer, so we don't use agents or brokers. You mentioned Baxter. So we, not only does it kind of create some rate stability for us where we don't have to pay commissions, there's no pressure on us by agents, but also it drives a lot more effective communication directly between our policyholders and our team of attorneys. So, you're not going to, so picture 1 a.m., you're in the OR, something terrible occurs. The very last thing that you want to do is dial an 800 number, get pigeonholed into the phone tree that we all know and hate. You spend 5 minutes selecting all the different options just to get a general voicemail that you're hoping someone's going to call you back on. It's the worst.
Right.
Everybody's had
Yes.
that.
And they check that voicemail 4 days after they got out of the office or got back from being out of the office. And you never get a reply. Meanwhile, the wheels of the issue are still spinning, right? Not to mention your internal emotional state.
Yes. The emotional piece of it, I think, is kind of undersold. And, our team of attorneys is available 24/7, 365. We have a phone system that rings between everyone's cell phones until someone answers. And so you can always get one of our attorneys. That's, included with your premiums. It's not like we charge extra for that or anything, the real-time advice. And so, it'll put people at ease. And also it gives our attorneys the ability to really jump in quickly, provide guidance, provide recommendations that help decrease the odds of an adverse event turning into a claim.
Sure. Yeah, that makes sense, which I want to come back to that. But you mentioned brokerages, right? And or agencies. I don't think I have a vague understanding of what that means in terms of a service firm, right? Just kind of an organizing umbrella. But what are those things and why don't you have them? They seem like they're useful. But yeah, please weigh in.
Yeah. So the most common distribution channel for insurance in the U.S. is agency distribution. So you
right, and that's your State Farm agent, right? Your local person with the little business card, right? Okay, got it.
And their
that's the
value
agent.
proposition is generally, I can take your insurance to market. I can have the carriers, work against each other to get you the lowest price. I can answer all of your questions that you have about insurance. Because it's kind of nebulous. Nobody really likes to talk about insurance. There are a lot of questions out there. Is this covered? Special.
And there's a million different types, right? There's a million different types of insurance. Even I'm just like, oh my gosh. So that's why I call you guys, right? It's just easier.
Exactly.
And by the way, we receive no financial benefit for this pot. There's nothing funny going on here, right? This is just to have a good conversation. But I do think effectively what I hear you saying is you don't have those agents, right? And you don't, go ahead, please clarify.
Yeah. So 90% of our book of business is direct, and I have my agent's license, but I work directly for the company so that I can answer the insurance specific questions that an agent normally would, but we don't have to deal with the, rigmarole and the ineffective communication and some of the things that come along with agency distribution.
Right. And that, I think I'm sure there's some upsides as well. Just like I think in the service sector at large in the United States, there's always upsides and downs, like in-house counsel versus outside counsel, right? There's always upsides and downsides. And obviously you guys effectively have both on the counsel side. But so effectively you're acting as the de facto agent if there was one, right?
Exactly.
And you're not, dealing with, I'm communicating with, 4, 5, 6 different carriers and trying to funnel that into a good option. It sounds like what you're saying is you're identifying the decision points in the financial decision and trying to reduce the variability, reduce the cost, reduce the confusion, so on and so forth. Correct?
Exactly. a lot of our competitors really like agency distribution because it creates a lot of opportunity for scaling, economies of scope and scale if you can really get your business out there via agency. But we don't really have that desire since we're so specialized.
Okay. Yeah, that makes sense. And then the steps between agency and brokerage, like is Baxter a brokerage? I honestly don't know.
I believe that they're an agent, not a brokerage, and really the difference is volume and lines of business offered.
Okay,
so brokerages are larger and they offer more products.
Okay, duly noted. So, for instance, like A&A Insurance Services, that would be an agency or a brokerage, one or the other.
Yeah,
correct. And okay, got it. And the actual carrier there is MedPro, whereas effectively you've streamlined that vertical into one company. Is that a fair understanding?
Yeah, that's accurate.
Okay, got it. That makes sense. And then in your introduction, you said something that stuck out to me, and in regard to who owns PP&M, right? There's no private equity involvement, which is a big topic in healthcare right now. I believe, if I'm understanding it correctly, it is owned by its policyholders.
That's correct. So we are a mutual owned by policyholders. Now, it's kind of a complicated structure that we have. Ultimately, control of the company does roll up to ProAssurance, which is a publicly held company out of Alabama. They're a pretty large MPL carrier. They offer a lot of lines and they are multi-specialty. So think of us as like the policyholder-owned, niched-out arm of ProAssurance.
Okay. Duly noted. I imagine that comes with some sort of financial backing, some resources, so on and so forth. That's why you're part of a parent company. But you're the anesthesia-specific niche company, correct?
That's correct. And so we enjoy quite a bit of autonomy. We get to set our own rates and choose where we want to focus as far as getting business, who to hire and that sort of thing for internal employees. But we enjoy the financial backing of the parent company, specifically with reinsurance. So it's kind of complicated insurance nerd stuff, but
yes, that sounds reinsurance sounds complicated. Yes,
just think layers of insurance on top of layers of insurance.
Okay, duly noted. Yeah, because insurance companies have to have insurance, right? In case their coffers run dry, so to speak. It's all about mitigating the risk, so to speak. Okay, I want to come back to some of the business stuff, but to flip back over to the practical side, Paul, as far as for your insureds, right, I'm thinking about things they can do effectively immediately, right away. What's one smart, proactive thing that I could do as an anesthesia provider this week or today to reduce my malpractice risk? What's something practical and immediate that I could change in my practice to begin to reduce my risk?
I might offer two, if that's okay. One more specific,
Please.
Clinical, and one maybe just an overarching general type of thing that we might see with our cases. I think that communication in the perioperative setting, starting, both with the patient's family, colleagues that you're working with, and just across the board, we do see those instances where there could be an adverse event attributed to a lack of communication, lack of understanding. So those types of things. It's such a unique relationship that the anesthesia professional has with the patient. It's not like a physician-patient relationship like a surgeon might have with the patient or a primary care physician. You're meeting your anesthesia professional on the day of the procedure. They might be the first person you meet in the morning, and they might be the last person you see when you leave. But they're not choosing you. You might just be assigned to that OR that day. So those opportunities to develop some rapport with the patient, answer questions. I know that there's oftentimes lots of questions about informed consent and things like that. And something we'll always mention is it's a process. It's not a signature on the form. It's, and every case is unique. Every situation is unique in what that process might look like. But I think those opportunities, as well as effective communication, amongst the clinical team as well, where certainly don't want there to be any misunderstandings or areas where you might invite exposure just because we know we're busy, but relaying some information.
And there's production pressure.
Helpful. Exactly. And then more along the lines of a specific patient safety issue that we're currently focused on, and always will be for the foreseeable future, I think is any listeners out there that want to evaluate their facilities, medication safety practices and things like that. So, we continue to see medication errors. Those are the types of preventable outcomes that we try to do what we can. We work closely with the Anesthesia Patient Safety Foundation.
Love that.
On the priority group for medication safety. Wrong route, wrong drug, administration errors, overdoses in the context of the incorrect dose being administered, and also known risk or known allergies. Sometimes that might be an oversight in the medical record. Sometimes it might just be educating the patient about a pseudoallergy, or this is a side effect of the medication, and I understand that you experienced a cough from this, or you had some nausea after, I'm going to give you some medicine when we're done with the case. And I do, think that if this particular drug would be helpful for you in controlling your pain, or make you, just taking a couple minutes to maybe educate the patients on some of those things would be helpful. And then, if you have a perioperative pharmacy on site that can help with ready to administer products, we've seen a uptick in tranexamic acid bupivacaine mix-ups in recent years, unfortunately. I think it was the POISE study in 2021, as an orthopedic journal, discussed kind of prophylactic administration of TXA for hips and knees, major joint
I gave it
procedures.
yesterday.
Oh, okay.
Yep.
Yeah. So, some of our insureds work at facilities where those are coming, pre-mixed in infusion bags and being brought up. Maybe they've got a spinal kit where everything is kept separate the whole time, but certainly have a large share as well that are taking those drugs out of the tray, or preparing syringes in advance on their own, and those might end up in the same pocket, things like that.
Sure.
So they happen
Easy
for
to
a variety of
quick.
reasons. Exactly.
Yep.
Frankly, sometimes it's amazing it doesn't happen more often. The multitasking and the directions that you guys are being pulled in every day. So I think that if there are opportunities to improve medication safety practices at your facilities, it should be a team sport as well. So coordinating with pharmacy, if there's, if you're administering medication for a surgeon, maybe getting their help lobbying for a change too. There are pre-filled infusion bags for TXA that come readily available too if you don't have a pharmacy. Not working for a pharmaceutical company or anything like that. I don't even know who prepares them.
Of course.
That as a specialty, anesthesia is unique and how patient safety oriented they are. So always lots of buy-in, and other members of the clinical team look to anesthesia oftentimes for identifying these issues. So speaking up and identifying problems go a long way.
Yeah, that makes a lot of sense. And I love the work, Anesthesia Patient Safety Foundation. You guys don't know this, but have you met Mark Warner before?
I have. Mm-hmm.
Yeah, cool guy. So I was a lowly little chief CRNA out in, effectively rural Arizona, small town Arizona. I wrote that guy an email during COVID, and he wrote me back, with a very thorough, I could tell he typed it himself, answer. And I was like, that is a very cool thing. It's a very human thing to reach out to a relative unknown, because he didn't know who I was at all. Love, appreciate that work. You said that consent is a process. Tell me more about that.
Sure. So look at the informed consent process. It's not a signature on a form. It's the patient has autonomy to make a decision about their medical care. So that goes to the ethical side of medicine as well. It went away from the clinician-centric to the patient-centric. So, it's not here, take this medicine, it's good for you. It's here's, the procedure we're going to perform today, and here's the anesthesia plan. If you, have a ASA 1 that's coming in for, an ankle scope or something that, minor procedure, highlighting some of the potential risks that might be unique to that, tailoring it to the patient, taking a few minutes to highlight some of those risks. It doesn't mean that you have to scare the life out of them by going through the absolute worst case scenarios of things. But if they've got an opportunity to review, we're certainly proponents of an anesthesia-specific informed consent form. We've got
Indeed.
examples
Indeed.
on our website. You can, breaks it down by anesthesia plan, give the patient a few minutes to review the form, talk about it with their family if they want to, see if there's any questions. And then it's essentially the patient saying, I appreciate these are the risks of the procedure. And notwithstanding those, I think the benefits of undergoing a surgical procedure are going to outweigh those risks. So I, the patient, am choosing to proceed. So I think it's just, being available to answer those questions. And again, it's another touch point to develop that rapport, because that's a personal conversation oftentimes. It can be.
Would you agree? Okay, I sound like a plaintiff lawyer. Would you agree with the following statement? But would you agree with the idea that, because you said you don't have to scare the patient, and I think that's when clinicians here review and informed consent, they think of every possible detail. That's how our brains are used to processing information, because we don't want to miss anything, right? I often advise clinicians, providers, what have you, it's your responsibility to share the relevant risks, the most relevant risks to that anesthetic, not necessarily to the surgery, but to the surgery in how it relates to the anesthetic, and maybe even, for the facility, right? If you're talking about the risks of a surgery center versus a tertiary care hospital, rather than contrasting that to reviewing, you may die today. You may die from these 5 different things. And I'm going to take 10 minutes, in the middle of this busy surgery center to review all the things you may die from, and 2 minutes or 2 seconds maybe, reviewing the most relevant or the most applicable or the most likely risks. Would you say that's a reasonable strategy with informed consent in that process?
Yeah, I do. It sounds like you're tailoring it to the patient. You've got a ruptured AAA, and you might have a conversation with the patient and their family about, prospects of there being a serious complication during the procedure. And you have an ASA 4 or an ASA 5, and that might be a conversation that takes place. If it's contained on the informed consent form as well, and I think giving that to the patient in advance and giving them the time to review it. I might want to review every risk that's on there. There might be another patient who, couldn't sleep the night before the procedure and is already anxious, and we know that there's a correlation between, anxiety pre-op and post-op recovery. There's literature out there to suggest that's the case. So you've got your North Star is the best interests of the patient. And if the best interests of the patient are just to highlight some of those specific risks that are maybe pertinent to them and that particular procedure, and it might just be, most likely risk that could occur here is you bite down on the endotracheal tube, or you're grinding your teeth as you emerge. You've got, a bridge or crowns that, dental injuries are common complication of general anesthesia. And have a conversation with the patient about that. That might be it, or it might be for a regional block. We do see lots of, it can get a little messy sometimes because you don't know whether it's the tourniquet time, the boot, the traction, the block, but oftentimes
all sorts of bad things.
Yeah. When you find out about it for the first time, 90 days post-op, it's usually because of the block by then, because the patient's talked to the surgeon. They've been referred over.
Whatever you do, I've never experienced that before.
Right.
Yeah.
So, highlighting those risks, just because, again, I think that there's literature out there to suggest that there are claims that are pursued legitimately by patients who just want to know what happened to them that they didn't know.
Of course.
That conversation taking place. It's a lot easier when the patient wakes up with a loose crown when you had the conversation before the procedure took place, than rather you're telling them about that being a risk for the first time when you're in the PACU.
Yeah, that makes a lot of sense. Paul, one more question to you, and then I want to open something up for both of you. For those who have, because you're working with providers, right, professionals, clinicians who are going through that malpractice process. You mentioned, effectively second victim syndrome, right? It can be very traumatic for them, very difficult for them. Often, this really settles in with people. It can be a very devastating experience. Even if they win, it can be stressful. So with that in mind, from your point of view, what separates those who go through these very difficult experiences, and bounce back and get up to, 30,000 feet and they're at fighting weight again, metaphorically speaking, and they're doing really good. They're back and providing great care to patients, versus those who it really, affects them long term in a traumatic way. What do you think the difference between those two scenarios is?
I suspect, and I can only speculate, to be honest, because it's kind of it would be a personal thing, case by case basis. It could be support structure that they have around them, both within their professional groups, maybe at home, as well as feeling supported at the hospital. Reassurance that, you didn't do anything wrong. There's nothing worse than sitting through a trial. Again, we know that the case is entirely defensible on the medicine, and we know we've got reputable experts, and they found a professional plaintiff's expert who does it for a living and has made millions of dollars flying around the country testifying, against anesthesiologists and CRNAs. If the jury is following the medicine and the judge's instruction, this is going to be a defense verdict 99 out of 100 times. Just, you can get unlucky with a jury, but this is those types of really defensible cases. But, when we're talking about a wrongful death suit, we are in a room for 1, 2, maybe even 3 weeks in front of strangers where you're being blamed for the death of another human being. I think sometimes that's not appreciated enough, about how stressful that experience can be. I think that there's a weight that's lifted off your shoulders once the jury, returns that verdict and absolves you of wrongdoing, which, again, going through that process, it's the vast majority of the time when we get to that point, if that's the direction of the file based on our experience in handling those cases. But I think that, just having that support, starts with us. I can only control what I can. And obviously we want to provide all the support and resources that we can for those individuals. Never once sat in a meeting where someone said, "Oh, well, why did you approve this expense?" Or, "Why are we defending this case?" My dad's a physician, my mom's a nurse. I come from a family of clinicians. If, those were conversations at the dinner table growing up, kind of thing. So I know how it can affect folks at home, but we've never had that cost of defense. Well, can we settle this case for X? The care can be defended, doesn't matter if it's a dental injury or wrongful death case. We have supportive experts and an insured that wants to defend their care, and then that's the file strategy, which makes my job easier in that it's a binary choice instead of some nebulous, what are we talking about at the meeting today kind of thing.
Right. No, that makes a lot of sense. I have one more. Actually, I have a follow-up question from what you said for you, Andrew. With PP&M, where do you fall in terms of, and you may not know, from an evidentiary point of view or evidence point of view, but where do you think PPM falls in terms of the size of other insurance malpractice companies?
So insurance is not immune to all of the consolidation that's occurred within many of the industries around the U.S. over the last probably 20 years. So, and our market share does vary significantly from state to state. So, there are some jurisdictions that are just not as attractive to us.
Of course, yeah.
Yeah, we try to stay out of there.
New Jersey, is that what you're saying? You're picking? No, I'm just kidding.
You know what?
We love New Jersey.
You'd be surprised.
Yes, Bruce Springsteen and all those things. But yes, I'm from Philadelphia, so I like to pick on New Jersey.
Sure.
Anyway, please feel no pressure to answer in terms of specifics, but maybe even this is the biggest, this is the smallest, and there's 4 or 5 levels in where we fall. I don't want to put pressure on you to answer with specific industry data or anything like that.
No, that's fine. If you look at it in terms of our parent company, ProAssurance is the 3rd largest of insurance or MPL carrier in the nation.
Okay.
So that falls behind the Doctors Company and Medical Protective.
Okay.
And as a company, we insure PPM specifically, we insure roughly 20% of the physician population. And CRNAs, it's a little bit more nebulous.
Right, because you're insuring practices, right? And then it may get harder to quantify in the data, and then you have your independence as well, right? So on and so forth.
Exactly. And, I'd say that our number one competitor right now is not TDC or Medical Protective. It's hospital employment. There's a lot of pressure on these groups to join hospitals. And if you'd asked me that 5 years ago, I probably would have said private equity and all the consolidation that occurred there. But that's kind of slowed, and we've seen some non-renewal of contracts, some things that kind of hint that we're headed the opposite direction. But hospital employment is our number one competitor. We've actually not lost an insured group to a competitor in over 9 years. So
very nice.
Solid record that we're proud of there.
That's impressive. And I think we're going to talk about hospital consolidation on another episode, but it's interesting to me from a service sector dynamic. I always tell people, look, if I can fix my own plumbing without calling a plumber, I definitely will. Right. But it's when these problems become more and more complex, I'm not sure hospitals will get what they're looking for. They'll probably gain on control, but lose on cost. I digress. That is definitely a subject for another time. I deal with that quite a bit. Just keep my eye on the time here. I want to close out with this question for both of you. So, Andrew, obviously you're on the business side, right? You've got the business degree, the MBA, so on and so forth. Paul, you're on the legal side. What is if you could, dispel wisdom to the 120,000 or so anesthesiologists and CRNAs out there, what's the one thing you wish you could tell every new CRNA or anesthesiologist when they're choosing their malpractice carrier, realizing that obviously not all lawyers are the same, right? And not all malpractice companies or malpractice policies are the same, even though from a generic point of view, they might seem interchangeable, but both from a business point of view or maybe the features point of view, and then from the legal point of view, what's one thing you could share with all of those individuals before choosing their malpractice carrier?
So I'll go ahead and answer first. On the business side, I would say you ask them, well, it's kind of a two-parter, but basically I would ask them, who do I contact in the case of an adverse event? And we're thinking about the carrier, not the agent. So, kind of keep that in mind, because that, the agency piece can kind of convolute who to talk to about what.
Right. Definitely. The agent might be trusted and friendly and so on and so forth, but at the end of the day, it'll be the carrier and the policies that you've signed on to making the decisions. Yeah.
Yeah. And make sure that you're not reporting those incidents to the agents. There can be some legal complications from that, from a depot perspective. But, so you ask them that question and just kind of assess their response. Am I sending these in via email? Am I calling? Does it have to be in writing? There are some carriers out there that have really specific rules about whether or not coverage is triggered. So, who do I report to? How do I report? What information needs to be included? And what's the process look like thereafter? So you met Tracy Djokovic last weekend, and at the AZANA, just so everyone knows for the the listeners, she was asked a question at the end of her presentation about reporting. There's a misconception out there that over-reporting, or what you perceive to be over-reporting, can have a negative impact on you as an insured, specifically your premium. So I think that at least specifically with PPM, that couldn't be further from the truth, and I hope that that's inaccurate with our competitors as well. Specifically looking at it through that patient safety lens. Not only does it help the carrier kind of triage right out the gate as far as risk management goes, but also it helps us keep our thumb on the pulse of exactly what's going on with claims trends. So if there's some sort of a trend within like a specific facility type or jurisdiction, we need to know about it. And if you're afraid of reporting to us, it's just going to move us further away from those goals.
Makes sense. And what about you, Paul? If you could dispel knowledge into the minds of all 120,000 anesthesia providers out there, what's the one thing they should know before choosing their malpractice option?
I think kind of to piggyback a little bit, but I want to go a little earlier on in the process before there is a claim or an adverse event. I think that we offer risk management resources, patient safety resources. I really want to look at our relationship as a partnership with our groups and our insureds as far as advancing patient safety. And so we spend quite a bit of time on what we call special services, things like that. Our risk management program, we do 30 anesthesia-specific risk management seminars or more each year between my colleagues and I. We contribute to a number of publications, including our own internal risk management newsletter, and as well as the APSF newsletter. Not a week goes by that we don't get a phone call or an email. I was talking to an anesthesiologist in upstate New York about an hour before we sat down for this discussion today, and he had a question about Department of Health coming by, and they had a meeting about their informed consent process and some issues on the form or some changes, and just looking for some general guidance. Or we had questions about student trainees and paramedic students intubating patients. All kinds of questions about potential liability exposure associated with this, or how can we advance. I was talking a little bit earlier about medication safety practices, just kind of a real-time conversation about strategies for that individual facility, that individual practice environment, to try to advance patient safety. And that's a common goal that we share. If we could get to a point where we dedicated 95% of our time to that and 5% to the claims and lawsuits, that would be ideal. And if we ever got to 100, I'm confident I'd be able to find something else to do anyway. So
Indeed.
That'd be a place that I'd start too, is what types of resources do we have to keep me out of the frying pan in the first place.
Yeah, indeed. Those are great services, guys. Thank you so much for being on. There's so many different ways we could take this, but and I'm known for my verbosity, but I want to distill this down into something useful. So we're gonna leave it right there. Thank you so much for being on.
Thank you.
Thank you for having us, Joe. It was a good time.
Absolutely.